Hi, this is Josh Blackman. I am the president of the Harlan Institute, and I'm happy to host the 2020 Harlan Institute ConSource Virtual Supreme Court competition. This will be our 10th match. We have a team from Creekview High School. We have Abby Park and Samantha Watkins, and they will be representing the petitioners in Espinoza versus Montana Department of Revenue. Petitioners can begin whenever you're ready.
May it please the court, my name is Samantha Watkins, and along with my co-counsel,
Abby Park.
we represent the petitioner Espinoza in today's case.
In our time before the court today, we will be addressing 3 points as follows. Firstly, that absent Rule 1, the tax credit program enacted in Montana Senate Bill 410 complies with First Amendment jurisprudence. Secondly, that the Montana Constitution's Blaine Amendment violates the free exercise clause of the First Amendment as it bars aid to students simply because of the outward religious character of the schools. And thirdly, that the rationale behind Montana Supreme Court's decision to level down is unconstitutional.
Would the court benefit from a brief recitation of the facts?
Please.
In 2015, the Tax Credit Qualified Education Contribution Act, or Montana Senate Bill 410, was enacted by the Montana legislature for the purpose of allowing individuals to donate money to nonprofit or private scholarship organizations, and for eligible recipients to receive up to $150 in tax credit. Big Sky Scholarship, a scholarship organization, created a program intended to award scholarships to all students of both religious and non-religious schools.
The petitioner, Kendra Espinoza, and other families applied for the scholarship to keep their children enrolled in Stillwater Christian Academy, as the school was private and required the cost of tuition. Not long after the program was created, however, the Montana Department of Revenue enacted Rule 1. This regulation dictated that the scholarship could not be provided to students at any sectarian institution owned or controlled in whole or in part by any church, religious sect, or denomination.
At trial, plaintiff argued that the tax credit program, as it was originally intended, was constitutional, but by the addition of Rule 1 to the Montana Constitution, it violated the free exercise clause of the First Amendment of the Constitution. The motion for summary judgment was granted on appeal. The Department of Revenue argued that the tax credit program is unconstitutional and Rule 1 does violate the free exercise clause.
Okay, Counsel, if I could interrupt just for a minute, I appreciate the recitation of the facts. You've talked a lot about the free exercise clause. Can you talk for a minute about the establishment clause, right? How does the establishment clause affect the outcome in this case?
Well, Your Honor, in this case, we actually are not arguing the establishment clause in particular. However, the establishment clause inevitably comes into play when we're referencing the free exercise clause, especially with something like religion. The establishment clause deals with the indirect or direct aid of funding for religious, in this situation, religious schools. And thus we're here to find out whether the state of Montana violated the establishment clause in funding this program.
Counselor, let's talk for a minute about Article 10 of the Montana Constitution.
Yes.
Why do you think Montana added Article 10 to the Constitution?
Well, Your Honor, respondents may have you believe that this was due to their efforts to keep the separation of church and state as balanced as possible. However, we are here to argue that this remedy was just a shield for its discriminatory intent. And that brings us to our first point as follows, that the tax credit program enacted in Montana Senate Bill 410 was constitutional, as it complied with First Amendment jurisprudence, both parts, the free exercise clause and the establishment clause.
Well, let me just interrupt briefly. Maybe Samantha can answer this question for me. What evidence do you have that Article 10 was a shield for discriminatory intent? I think that's what you said a minute ago. What evidence do you have to support that argument?
Are you, when talking about the Rule 1 and how it Can you rephrase your question, Your Honor?
Well, your co-counsel a minute ago said that Article 10 of the Montana Constitution was trying to shield a discriminatory intent, like an anti-religious bias. What evidence do you have to support that?
Your Honor, when looking at the reasoning stated for getting rid of when looking at the reasoning behind Rule 1, its
No,
sole
I don't want
purpose
to hear
is
about. I don't hear about Rule 1. I want to hear about Article 10. Let's focus on the Montana Constitution for a minute. Well, I think Abby, correct me if I'm wrong. You said a minute ago that the Montana Constitution was Article 10 was motivated by discriminatory intent. What evidence do you have to support that?
I think she misspoke. I think she was talking about Rule 1 under the Montana, not Rule 410. Rule 410 by itself is constitutional, but when adding Rule 1, violating all religious private schools, then it is therefore unconstitutional because
okay, then if I misheard, I apologize, but I want to talk about Rule 10 for a minute. I'm sorry, Amendment 10. Why do you think Montana added Amendment 10 to their constitution? That's my question.
The one that
I think I misunderstood. I thought you were talking about Rule 1.
No, I'm talking about Amendment 10, right?
Did the Montana Senate Bill 410?
Article 10 of the Montana Constitution. What does Article 10 of the Montana Constitution say?
We did not.
Okay.
That
are you talking about
that's
the
under contention?
410?
The no aid provision in the Montana Constitution. Okay.
Oh, so you're referencing the Blaine Amendment, Your Honor?
Yeah, the Blaine Amendment. That's what I'm talking about.
Okay. So it was actually not stated in the facts as Amendment 10, I think. So we were just confused because we have been referencing it as the Blaine Amendment.
Okay. Well, Article 10 in the Montana Constitution. Why do you think that was added to the Montana Constitution, the Blaine the amendment?
Do you want me to answer this?
Either one's fine.
Oh, so, okay, so you're asking, sorry, just to clarify, you're asking why we think that there was discriminatory intent behind this rule?
What's the purpose behind the Blaine amendments?
Oh, okay, so I think I answered this in part, that the respondents will have you believe that it was due to the state's efforts to upkeep the principle of separation of church and state, and it was created to maintain that balance. But we're here to argue that it was by invalidating religiously neutral programs such as the one in contention, it wasn't a reasonable framework. If that.
All right. Well, okay. So let's move on. What's the strongest case in support of your position?
We actually have a few cases that we referenced, but we to support our framework, we mainly used Trinity Lutheran versus Comer and Everson versus Board of Education.
Okay, so how does Trinity Lutheran help your case?
Well, as the ruling in Trinity Lutheran versus Comer states, we can analyze the program under it. We can look to the court's ruling that it was sufficient that the law denied a religious organization the same opportunity to compete for a benefit that is otherwise available to all secular organizations in order to be deemed unconstitutional. So then we can invert this court's reasoning, therefore, that the free exercise clause is fulfilled as long as there is equal opportunity for competition between both secular and religious organizations for a benefit inside that program. And we can see that this is the case for the tax credit program in contention today. Both secular and religious schools were valid participants of the tax credit program, and the program in no way restricted competition between both for the same benefit being awarded.
Counsel, let me if I can interrupt you just for a minute. In Trinity Lutheran, the school was denied funding for playground equipment, basically tire scraps in the playground, right?
Yes,
what
sir.
is the money being used for in this case? How is the money being spent?
In this case, actually, the money goes in the form of like a tax rebate. So first, it goes to the it's kind of like a tax break for the taxpayers in Montana who choose to contribute to the education of Montana, and those funds that are received go to the parents, who then can choose to spend that money by choosing a variety of options in the schools that are involved in the tax credit program.
Counselor, maybe a question for Samantha. Can this money be given? The money that's given to the schools, could it be used to purchase Bibles?
When looking at the program itself, the program is meant for tuition, and that tuition can be put towards anything, whether it be a religious school or not. It is not, when going into those specific details, such as those, it can be a slippery slope when arguing. And when looking at this, it's...
Well, I know, but just my question, I think you answered it, but can this money given to the schools be used to purchase Bibles? Let's say for students' tuition, they need to have a Bible at every desk. Could this money be used to purchase Bibles?
Yes, it could, but the money is intended to go towards tuition, but when looking at this as a whole, the parents can apply to go to any school.
Well, I get that. I get that.
So,
Counsel, can you draw a distinction then between Trinity Lutheran in this case? In Trinity Lutheran, they're paying for playground equipment to keep kids safe. And here, there's no restriction. It's being used potentially to buy Bibles or to help students learn to pray. Isn't this different than Trinity Lutheran?
yes, Your Honor. Well, it is different in the fact that the money is going to the school, but where the line is drawn is the fact that the money doesn't go directly to the school to spend on anything. The money goes directly to the parents, and the parents choose where they send their students or where they send their children. Their children can go to an array of schools, whether it be a private or non-private school. And by the Blaine Amendment excluding specifically religious schools, it's unconstitutional.
Okay.
And
Your Honor, may I add?
Please, go ahead, Counselor.
Oh, okay. So we can also reference the standard set in Zellman versus Simmons-Harris when we are judging this, in which this court ruled that if a program afforded parents free private choice in choosing schools for their students, then the program would be deemed religiously neutral and constitutional. We can get this from the quote, that the program was one of true private choice with no evidence that the state deliberately skewed incentives toward religious schools was sufficient for the program to survive scrutiny. So just like the program in Zellman, the tuition aid that the program in contention planned to distribute to parents is according to financial need, and where the aid was to be spent depends solely upon where parents choose to enroll their children. The student aid program neither stripped the parents of true private choice nor advocated for a certain religion in any way. There were both legitimate non-religious and religious schools that were viable options for the parents at any time. It's just a commonly understood fact that many private schools are religious, but this does not change the fact that there were still viable options for both available for choice by the parents.
All right, Counselor, can you tell me about Locke v. Davey? How do you distinguish this case from Locke v. Davey?
Do you want me to answer?
Either one.
Okay. So when we look at Locke v. Davey, the difference between the cases is that in this case, specifically, the tax credit program, there was no direct channeling of aid or funds to any of the members of the school or the school itself. It goes directly to the parents. So the school is actually removed by these aforementioned levels. And I can bring up like a similar analogy for your honors to better understand our argument. We can think about how the federal government gives tax breaks for charitable donations. And so we can see that this program is more similar to a charitable donation tax break system rather than a religious funding system, since it's to incentivize taxpayers in Montana to contribute to the education of Montana rather than advocate for any religion.
Okay, Councilor, you have about a minute and 15 seconds left. You can move towards your conclusion if you'd like.
Oh, okay.
To conclude, the tax credit program enacted by Montana Senate Bill 410 complies with the First Amendment's jurisprudence absent Rule 1. Additionally, the Montana Constitution Blaine Amendment violates the free exercise clause of the First Amendment as it bars student aid simply because of its outward religious character of the schools. And finally, the rationale behind the Montana Supreme Court's decision to level down is unconstitutional.
It is for these reasons we pray that this court rule in favor of the petitioner and reverse the lower court's decision. If Your Honors don't have any further questions.
No, very good. All right, counsel, you have
Thank you.
5 minutes to move on to rebuttal. You can begin whenever you're ready.
All right. Okay. May it please the court, in my rebuttal before the court, I will be presenting 2 points in response to opposing counsel's argument and clarifying a few points from our argument as well. Firstly, the respondents argued for a state authority that is unrelated to the case at hand, and secondly, that the respondents claim that our argument will set a precedent of one-size-fits-all approaches is unsubstantiated. The basis of respondents' argument relies on the contention that the state controls religious funding, and that by forcing the state to fund religious schools, this court would violate its constitutional authority and subsequently the system of federalism. I would again like to remind this court that direct religious funding was and is not taking place in this case. To clarify our argument, I brought up that realistic analogy of the charitable donation tax break system. In that system, the state is not ever straightforward in any direct way donating any aid to any religious schools, and thus the Blaine Amendment directly...
Counselor, do you think, if I can interrupt, do you think the Blaine Amendment is unconstitutional?
As applied to this case, yes, sir.
So are you asking us to declare the Blaine Amendment unconstitutional in this case?
So we find that yes, Your Honor, we find that the Blaine Amendment, as applied, as it invalidates a religiously neutral program, was unconstitutional.
Now, you keep saying unconstitutional in this case. Where would it be constitutional, right? The Blaine Amendment says you can't provide aid on the basis of religion. You seem to be saying that Trinity Lutheran says you can't do that. In what circumstance would the Blaine Amendment be constitutional?
Well, Your Honor, we propose some basic frameworks for future legislation that the state maintains a safeguarding of indirectness and neutrality when it comes to legislation like this, as it is so that it can be a little bit sensitive. But we do agree with the respondents that the state does have the authority to choose how they can fund religious schools in that sense. However, in this case, the program in contention did not have to do with religious funding at all and was still struck down. And so we find that the Blaine Amendment was unconstitutional, and subsequently Montana Supreme Court's decision to level down was also unconstitutional.
All right, never proceed, Counselor.
Okay. Around 5 minutes and 56 seconds into opposing counsel's argument, opposing counsel conceded that absent Rule 1, the tax credit program did not violate the free exercise clause. Thus, respondents contradict their argument when stating that the Blaine Amendment is still constitutional. The invalidation of a religiously neutral program and the subsequent stripping of private choice of the parents involved is a clear violation of the Constitution's fundamental provisions. And I would just like to go into a bit of clarification on the terms leveling down and leveling up, something Your Honors are probably familiar with, but leveling down was something the Montana Supreme Court decided to do instead of leveling up, which was something they could have done to treat both religious and secular schools equally while still keeping the program. We are arguing that the decision to level down was inherently flawed and unconstitutional. Respondents do not bring up this point in any way, but we still find that it was at fault. This court recognized that simply leveling down to conceal discriminatory intent is unconstitutional in Village of Arlington Heights versus...
Counselor, I'm sorry, do you think there was discriminatory intent here? Who had a bad intent in this case?
Your Honor, we find that there was discriminatory intent because there was an express exclusion of the parents who wish to send their children to religious...
But wasn't that exclusion required by the Blaine Amendment, by Article 10?
Sorry, Your Honor, I did not hear your question.
Wasn't that exclusion required by state law, by the Blaine Amendment? Didn't they have to exclude those students?
No, Your Honor, because in this case, again, the tax credit program was completely religiously neutral, and that it should not have been affected by the Blaine Amendment, and yet it was, and
But the
that just
state
shows.
but state law said you can't give aid to religious groups. They were required to. Samantha, you can answer. You have about 20 seconds left, so you're almost at the end.
Your Honor, when looking at the Blaine Amendment and what you're referencing and the fact that it said that we cannot, that said we are allowed to say no to the religious schools, we can look to Locke v. Davie where it says that we are allowed to disfavor religion by placing minor burdens on religion to maintain the separation of church and state. But here, by taking this constitutional not organization, but program, by taking this constitutional program and adding this big burden on just religion just because of the fact that parents have chosen to place their kids in a religious school is unconstitutional and discriminatory towards religious schools and isn't a minor burden, it is a major burden.
Okay, Counselor, that's time. Thank you so much.
Would you like us to conclude, or?
No, you're out of
Okay.
time. But
Thank you.
thank you for that. I'd like to say thank you. You guys did a very good job. My questions are not easy. They're designed to make you feel uncomfortable. They're designed to push you and make you take a position. And once you take a position, I shove you over that line to see if you're willing to stick to it. So you did very well. I'm proud of both of you. Sebastian, is there anything that you'd like to add to our team?
Yeah, echoing Justice Blackman, it obviously takes a lot of skills and a lot of pluck to do something like this.
Thank you.
Obviously, these questions are tough, and this is obviously a really hard case. It's going to be closely decided, I'm sure, and the reason we chose it is because it's very interesting and has really no clear resolution or clear answer. So I try to put myself back in your shoes back in high school, and I never would have thought of doing something like this, and second, probably would not have been able to go toe-to-toe with you two at all. So great job.
Thank you so much.
Very good.
Thank you.
Do you two have any questions for us that you'd like to ask?
No, the YouTube video will be up right after this, or?
In a couple hours, maybe not right away, but we'll be up later
All right.
today. I have 4 other teams from your school. I'm sorry, 3 other teams from your school.
Yeah.
So I think I'll put them up probably later tonight.
All right. Thank you so much.
Thank you both so much,
Thank you.
and we wish you best of luck. Thank you so much.
Great.